continue to closure and denying the people. I'll be glad if internal security visits the site for themselves. But the fact of the matter is that we are denied our chance, and all we are pleading with is the gazettement of the insecurity status. Because the issue of toilets or pit latrine is actually a business that people have adopted. That the people who are there are actually, people who have dug pit latrines and hired to the people who want to use them. So it's not an excuse. But if the county government was asked to do it and they don't do it, then let's not deny our people the opportunity to benefit from it.
Thank you. Tongoyo, I would advise you, Tongoyo, to meet with the member whom you said you have been meeting, and your vice chair, and any other interested party from the area, because I think the problem are administrative issues that you can be able to sort out. So arrange, you have this afternoon, you have tomorrow, to meet with the members concerned. Thank you. Honorable Adewario, North Horr. Honorable Adewario of North Horr. Where is the chair agriculture?
the share of no government share of annual revenue divided by the Annual Division of Revenue Act enacted pursuant to Article 218 of the Constitution. The funds are geared towards community-driven development projects and in every constituency identified and implemented at grassroots level. The fund is managed by the NGCDF board, which is a body corporate established pursuant to Section 14, 15, and 16 of the Act. At the constituency level, the day-to-day management of the fund is vested in the National Government Constituency Development Fund Committee, vested in the National Government Constituency Development Fund Committee that are in place are in place in each of the 277,000 pursuant to Section 4 of NGCDV 5.
per the regulations that this House set. Thank you, Honorable Speaker.
Enough for statements. Next order. Order number 10. Order number 10.
Order number 10, motion. Consideration of an agreement on the establishment of the Global Green Growth Institute, GGGI.
Chair, Departmental Committee on Environment. Ngogoyo, you are a member of the committee?
Yes, Mr. Speaker.
Go ahead.
Yeah, thank you, Chair. On behalf of the committee, I beg to move that this House adopts the report of the Departmental Committee on Environment, Forestry and Mining on its consideration of the agreement on the establishment of the Global Green Growth Institute laid on the table of the House on Wednesday, 20th November, 2024. And pursuant to the provision of Section 8.4 of the Treaty, Making and Ratification Act 2012, approves the ratification of the Global Green Growth Institute. Mr. Speaker, while moving this motion, I wish to bring to the attention of this House that the GGI, the Global Green Institute, was established in the year 2012 at the Rio +20 United Nations Conference on Sustainable Development. The agreement on the Global Growth Institute was subject to ratification of the GGI, entered into force on the 18th of October 2012, following the signing of the agreement and a session. Growth Institute is a treaty base of intergovernmental organization that supports and promotes sustainable economic growth in developing countries and emerging following the signing of the agreement and a session. Growth Institute is a treaty base of intergovernmental organization that supports and promotes sustainable economic growth in developing countries and emerging, and Ratification Act of 2012. Upon a session of the Global Green Growth Institute, Kenya shall be required to attend and participate in the biennial meeting of the Assembly under Article 7.2, to invest in public participation and awareness of the programs on the green growth sustainability development. Mr. Speaker, accord the GGI privileges and immunities as may be necessary and appropriate for proper functioning under Article 15, guide and cooperate partnership and linkage with other international bodies, and cooperate partnership and linkage with other international bodies. Under Article 16, carry out all functions of the Ministry of Foreign Affairs and Diaspora. 3, the National Treasury and Economic Planning. And 4, the Office of the Attorney General. We observed the following. Having considered the agreements, the committee made the following observation. A, membership of the GGI will enable Kenya access finance and technical support to mainstream green and climate change, technical support to mainstream green and climate change actions in the national planning. 2, the memorandum to the GGI will enable Kenya benefit from sharing and gaining knowledge through multi-country cooperation. The global Green Growth Institute presents an opportunity for Kenya to explore and tap into the benefits of the green growth economy, which includes accelerating green financing and creating green jobs. Kenya is a beneficiary of the Green Climate Fund with a number of readiness and projects finance opportunities, access which has been enabled, and the current objectives with a climate lens. And GGI as a delivery partner is a great opportunity for Kenya to leverage for more project financing by the Global Climate Fund. The ratification of Kenya to the agreement establishes the GGI Institute and provides an opportunity for Kenya to participate fully in the Global Green Growth Institute activities, including voting rights in the GGI Assembly and Council. Mr. Speaker, the Global Green Institute will help us get funds from the Global Climate Fund. Now we will have a structure that is more organized, and the ratification of this agreement by this National Assembly will now make us full members of the Global Green Institute. Mr. Speaker, sir, Madam Speaker, the committee has, having considered the agreement, recommends that the House approves the ratification of the agreement on the establishment of the Global Green Institute. Madam Speaker, finally, the committee is thankful to the Office of the Clerk and the National Assembly for the logistical and technical support accorded to it during its sitting, the Ministry for their participation and the submission during the consideration of the convention. Mr. Speaker, I therefore request the Honorable Majority Leader Kimani Ichung'wah.
Proceed.
Mike. Thank you, Honorable Speaker. Honorable Speaker, I rise to support this motion on the Global Green Growth Institute. Honorable Speaker, just for information to the House, in addition to what the chair designate of the Environment Committee, the Honorable Ngogoyo, member for Kajiado North, has said that Kenya indeed did assent, or rather it's our letter of intent to join as a member of the agreement was done on the 23rd of November 2022 by the Cabinet Secretary then for Foreign and Diaspora Affairs in a letter that was addressed to the Director General of the Global Green Growth Institute. And the Office of the Director General communicated its approval of Kenya's willingness to join the GGGI on the 11th of January 2023. And in the same communication, Honorable Speaker, GGGI requested Kenya for a grant of the Privileges Immunity Agreement. And this immunity agreement, Honorable Speaker, a host country agreement, negotiation on the GGI agreement on the legal status and the immunity was held in July of 2023, with Kenya's negotiation team and GGGI representatives. As part of the accession process, a cabinet memorandum was submitted to the cabinet for approval for accession on May 2023, in line with Section 7 of the Treaty Making and Ratification Act, revised version of 2012. And further, the cabinet approved accession for the GGGI during its meeting held on 13th of December 2023. Further, on the 13th of May 2024, the Prime Cabinet Secretary and Cabinet Secretary for Foreign and Diaspora Affairs submitted to Assembly, and it is this memorandum and agreement that the committee has been considering and recommends its approval thereof, Honorable Speaker, by the House. It's important, Honorable Speaker, to mention that the main objective of the GGGI is to promote sustainable development of developing and emerging countries, including the least developed countries, by supporting and diffusing a new paradigm of economic growth, targeting key aspects of economic growth and economic performance, resilience, poverty reduction, job creation, and social inclusion, and creating and improving economic, environmental, and social conditions of developing and emerging countries through partnerships between developed and developing, or the carbon green economy. We will benefit from the knowledge, skills, and technology from other countries in the developing and developed countries. Also, Honorable Speaker, it seeks to provide policy advice and technical support in the development of green growth plans, policies and regulations, mobilization of green investments, implementation of green growth projects, and development of local capacities and knowledge sharing. Honorable Speaker, I said we stand an opportunity to be able to share knowledge between our country, other developing countries, and
on the establishment of a global house on Wednesday, 20th November 2024, and pursuant to the provisions of Section 8.4 of the Treaty Making and Ratification Act 2012, approves the ratification of the agreement of the establishment of a Global Green Growth Institute. The mood of the House that we put the question. Honorable members, I now put the question that this House adopts the report of the Departmental Committee on Environment and Forestry and Mining on its consideration of the agreement on the establishment of the Global Green Growth Institute, laid on the table of this House on Wednesday, 20th November 2024, and pursuant to the provisions of Section 8.4 of the Treaty Making and Ratification Act 2012, approves the ratification of the agreement on the establishment of a Global Green Growth Institute. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it.
Order number 11,
a court ruling 4242 Section 8, 12, 7 entity, audit, disallowable expenditure, economy, efficiency, grant, irregular expenditure, office of the Auditor General, public money, public resources, unauthorized expenditure. And these definitions, Honorable Speaker, have a bearing on the issues that were touched on by the court. That shall be, or rather the Auditor General shall be the accounting officer and staff appointed by the Auditor General. And it is worth noting that Section 4.2 of the Public Audit Act was declared unconstitutional because it provided that the office of the Auditor General was to comprise of the Auditor General as a statutory head and the other staff appointed by the Auditor General as may be delegated in Articles 234 of the Constitution, and this is what the court or Justice Muita did find to have been unconstitutional. And large reason that Section 4.2 of the Act resulted in an unconstitutional effect of reducing the constitutional office of the Auditor General into a statutory office. Therefore, Honorable Speaker, the amendments that we are seeking to do now under this clause 2 and 3 are to ensure that the constitutionality of the office of the Auditor General is not reduced. A constitutional office, and the Auditor General will continue acting as a constitutional office, largely to safeguard the independence and autonomy of that office, the office holder and the office of the Auditor General. Honorable Speaker, if you look at clause 4, it amends Section 5 again of the Act on qualification of for appointment of the Auditor General to include an additional qualification requirement for the Auditor General being a practicing member of good standing of a professional body of accountants recognized under the Accountants Act. This is important, Honorable Speaker, because we need to hold people who hold office in the office of the Auditor General accountable to a professional body. And therefore seeking to ensure that whoever is appointed to this office, part of the qualifications that you need to is a member of good standing of a professional body like ISPAC be anything. But for an accountant, 1 + 1 must be 2, and it cannot be anything else. And to safeguard public interest and public resources, we cannot have professions where 1 + 1 does not add up to 2. The people who we must entrust with ensuring of the bill, it amends Section 7 of the Act on the function power provide for an additional function for the Auditor General that meant by the Auditor General. It further aligns the responsibilities with the Constitution so that, again, to cure the problems that the judge meant by the Auditor General. It further aligns the responsibilities with the Constitution so that, again, to cure the problems that the judge, the good judge, didn't find to be unconstitutional. Honorable Speaker, this was a very detailed bill, and by and large, because it is aligning to what was found to have been unconstitutional by the courts, then, Honorable Speaker, we have nothing much really to debate on, because what the courts did find nothing much really to debate on, because what the courts did find unconstitutional to support. And as I indicated, the finance and national Finance and National Planning Committee did consider all these provisions and tabled a report before the House, which by and large agrees with what the court found. And we have no choice than to agree with them also. And therefore beg to move, Honorable Speaker, and urge the House to support because the Office of the Auditor General and that of the Comptroller of Budgets are two very critical offices under the architecture of the 2010 Constitution, because these are the two offices that ensure that, as we are seeking even to further amend in the role and functions of the Office of the Auditor General, that ensure that public resources are utilized not just in an accountable and transparent manner, that as we are now even further enriching to ensure there is not only transparency, public resources are applied in an accountable way, in an efficient way, in a manner that we can find value for money in how we apply public resources. And more importantly, Honorable Speaker, that these public resources applied are then done pursuant to set policies that effectively improve the lot of the Kenyan people. Honorable Speaker, if we fail to do that and if we fail to empower the Office of the Auditor General, man is bound by temptations, Honorable Speaker, and those who are charged with the responsibility of applying public resources will get tempted. But there must be something at the end of the day that tells you, however much you are tempted, if you touch public resources, there is somebody watching and superintending over those resources, and they will do it in a way to ensure that you did not only apply resources effectively and efficiently, but in a sustainable manner to ensure that the development of a country is safeguarded, and more importantly, to ensure that there is also value for money in the application of public resources. Because when there is no value for money, then, Honorable Speaker, we end up applying so much of our public resources in projects that at the end of the day don't give value to the Kenyan people and the Kenyan taxpayer. Honorable Speaker, we have been told Kenyans absolutely have near down the line because money was not applied, public resources were not applied in an efficient, accountable, transparent, effective, and in a manner that ensured there was value for money, then a year down the line, a road that was done to bitumen standards when it was a Maram road, Honorable Speaker. And we have seen it across the board, Honorable Speaker. The Auditor General also scrutinizes how resources, public resources are applied by state officers who are charged with that responsibility. Members of Parliament, all these members of Parliament bear the brunt of the public when roads are impassable. I witnessed, Honorable Speaker, the other day, an MCA, I think in Mlolongo, in Mavoko, being forced by members of the public, his own constituents, to walk through ponds of water because they feel it is the MCA who is failing them. But they forget the MCA, as a member of the county assembly, has no resources to apply in the implementation of government projects. If anything, the person they should have made to walk through that pond of water is either their governor or the county executive member in charge of roads. Tomorrow, Honorable Speaker, these members of Parliament will be made to walk through ponds of water again by their constituents who fail to understand that it is the same public who have told us, even under NGCDF, or even under the roads board money for the fuel levy, move out of implementation. The courts have agreed with everybody that members of parliament, their key responsibilities revolve around legislating what we are doing now with the Office of the Auditor General. 2, oversight. 3, representation. And I have seen members even this afternoon representing their people saying that there are certain roads, billions, hundreds of billions have been allocated to a few counties and not other counties and constituencies, Honorable Speaker. And I see the member for Alda is saying Kiambu. Kiambu, I can tell her, the billions you will see in Kiambu are trunk roads. The highway running from Westlands, from ABC, all the way to Rironi. You'll find you'd imagine roads in Kiambu are all done. They are not. That road runs from Westlands constituency through Dagoretti North, through Dagoretti South, through Kabete, Kikuyu, Limuru, and terminates just before you get to Naivasha. And Honorable Speaker, I was saying that because we have been told and accused, and with tremendous respect to the former Prime Minister, I've also seen him add his voice to that members of parliament must never be involved in the implementation of projects. And never be involved in the implementation of projects. And so it is for members of the county assembly to feel that the member of the county assembly is the one who should be fixing their road. Why is it today that members of the public in Kikuyu constituency feel that I should be fixing roads more than their governor, who has been given resources to fix their village roads? But they will keep coming to the members of parliament, because members of parliament are not just efficient and effective in the application of public resources that have been, they superintend in NGCDF by oversight through NGCDF. And so it is through CRC. If you go to all the 290 constituencies, and I've been around this country as we tangatangad, Honorable Speaker, and I still continue to tangatanga across the country, I can tell you, every other constituency you visit in this country, if you find a road being maintained, whether it is a Maram road or a bitumen standard road that is being sealed potholes, it will not be accounted by a county government. It will be through the constituency roads committees, or through KERA, or through KURA, or through KENHA. Honorable Speaker, I'm saying this because I said I will not be shocked if tomorrow a member of parliament is made to walk through mud by his or her constituents, which is very unfair, Honorable Speaker, because these MPs have no money to fix roads. But the people who are charged with fixing roads, those at KERA, those at KURA, those at KENHA, then implement these projects in a manner that is not cohesive, that is not transparent. That is why they bid rigging in. Honorable Speaker, the only person we can ensure is able to catch these thieves is the Office of the Auditor General. It is only the Auditor General then, empowered by this bill, when it becomes an act of parliament, who will be able to ensure that public officers apply public resources in a transparent and accountable manner, in a manner that is efficient and effective in the delivery of services, and in a manner that gives value to the people for every coin of their taxes, Honorable Speaker, so that Kenyans can pay taxes happily. I don't know whether there is such a thing as paying taxes happily, Honorable Speaker, because I read even in the Bible, Jesus Christ himself had to tell the people that give unto Caesar what is Caesar's, and give to the Lord what belongs to the Lord. That tells you that even in those ancient times, at the time of Jesus Christ, people are not happy to pay to Caesar. They are not happy to pay taxes. But today we are saying, let us pay taxes, but ensure that we get value for our taxes, Honorable Speaker. Because if we don't get value from our money, then we'll find no reason to pay. And therefore, Honorable Speaker, with those very many remarks, I beg to move and urge members to support all these amendments so that we align the Public Audit Act to the Constitution and also align to what the courts did find as having been unconstitutional. And therefore, and I believe members of parliament who transition on to be governors, and you can see from the case example of Governor Gladys Wanga. And of course, women governors or lady governors tend to do better. How I wish Kiambu we could get a lady governor. I don't know who, but Honorable Speaker, I wanted to ask the Honorable Naomi Wako to second.
Honorable Speaker, thank you. I take this opportunity to second, and as I do that, I must appreciate the words of wisdom from our majority leader on women leadership. He has always done it, and he will continue to support women until we achieve our goal. Honorable Speaker, looking at this amendment bill, Public Audit Amendment Bill 2024, National Assembly, is one of the best. And our very able is we have people who are not qualified for that particular offices. And if we have the right people, people who are qualified, the accountants, people who are professionals, then they can bring their professionalism into this. And in the Office of Auditor General, we will be able to account and be the good stewards that we need. Honorable Speaker, number 7, Clause 4 of the bill amends Section 5 of the Act, qualification for appointment as Auditor General, which includes additional qualification requirement, and that is a practicing member of good standing of professional body of accounting. Honorable Speaker, most of the time we have public servants who have been in corruption, who have been identified, who have corruption cases. And why we suffer as a country is because we the people who have bad records. And if we have practicing member of good standing, of professional body, of accounting, then we will have taken care of this and we will have safeguarded that office. Again, Honorable Speaker, I support and second this because under number 9, Clause 6 of the Bill 6 to repeal Section 8 of the Act, administrative powers of the Office of Auditor General. And number 1 under that is developing an organizational structure and staff establishment for the Office of Auditor General. Number 2 is recruiting and promoting qualified and competent staff. Staff, which most of the time is not the case. And I would also want to say, in any establishment of any office and any vacant and proposes the.
Thank you, Honorable Speaker. Honorable Speaker, I rise to support this motion, which, Honorable Speaker, I've had an advantage of looking at the ruling. Honorable Speaker, that ruling, I believe, set a very dangerous precedent, Honorable Speaker. If I'm not wrong, that ruling set us on a path where if matters are not audited on time and debated in Parliament on time, then those reports become irrelevant, regardless of what they contain. Therefore, it exposed us to loss of financial, public money, and therefore it is important to pass this bill. Honorable Speaker, one of the things and I believe the members of the Park and Peak committees, I'm seeing one of my members, Honorable Sigei here, who they ought to be listening to this issue. I've noticed Senate to be keen on some of these. We need the Public Accounts Committee, Public Investments Committee to audit some of these projects, and they will find there's a very big problem with the county governments. But otherwise, I don't want to say much on this issue. I believe by failure to pass this bill, we was putting us in danger. And it is important to notify the House that as a result of this ruling, Honorable Speaker, it means we need to be up to date. Audit committees need to be up to date with the financial year. Right now, every audit committee, whether it's PEAK, whether it's PAC, should be getting ready to audit the reports of 2023, 2024. Because the ones that some of our committees are looking at, 2021, 2022, 2023. Those ones, as per this proposed law, means that those ones have already been overtaken. In fact, one of the things that we asked the Auditor General was to appeal this specific ruling. Because if we allow this ruling to go as it is, without setting aside those orders, it means some of the work that the public investment, the PIC committees, the PAC committees have been doing. It means all those reports for 2021, 2022, 2023 are now time-barred. It means you cannot take any action against any perpetrators that we find. So Mr. Speaker, it is important that we pass this bill as it is, but I would also suggest heavily that this is the one led by Honorable Speaker, I forgot. Yeah, they need to, Honorable Speaker, to ensure that they've liaised with the Auditor General's office, ensure that
253 of the Constitution of Kenya. Honorable Speaker, under Article 15, they mention several independent offices and constitutional commissions that ought to be body corporates. And those ones obviously include the Office of the Auditor General. And so on this wisdom therefore, Honorable Speaker, we are creating the Office of the Auditor General as distinct from the Auditor General that is set out in the Constitution of Kenya. In essence, Honorable Speaker, we are literally enhancing the power and authority of that particular office to be more than just a mere constitutional office, but a body corporate capable of suing and being sued, holding assets and the related issues. Honorable Speaker, assets and the related issues. Honorable Speaker, I would then therefore, and a distinction must be drawn here, Honorable Speaker, is only the Auditor General who can append a signature on audit of public funds. It's only the Auditor General. Regardless that we are creating the Office of the Auditor General, it's only the Auditor General appointed under Article 2229 who can actually append the signature on audit reports. So therefore, it is important that distinction is drawn. We have no issues at all. Honorable Speaker, I really find Clause 8 that seeks to amend Section 11, B, Section 11, by inserting Section 1A, to be, Honorable Speaker, to be superfluous. And I hope the Majority Leader would listen to this so that when we are going to the committee of the whole house, he says so that we do not. Honorable Speaker, the appointing authority for the Auditor General is the President with approval of Parliament. Approval of Parliament is the President. I find the provisions under Clause 8B to be superfluous and unnecessary. And Honorable Speaker, this is what it reads. Where the term of the office of the Auditor General is due to expire, the Auditor General shall notify the appointing authority in writing of the contemplated vacancy 3 months prior to the expiry of the term. The import of that provision, Honorable Speaker, one, is that the appointing authority cannot remember the day they appointed and when the term of 8 years is coming to an end. Then that will mean, Honorable Speaker, is that the dereliction of duty by the person who is supposed to do this, whom we passed a bill here, the head of public service. I find it superfluous, unnecessary, and generally what I is telling the people of Kenya. And what happens if the Auditor General himself or herself does not define or does not notify the appointing authority. What happens? Are there any sanctions? Are there any penalties? Hoping time will allow, this is an amendment that we need to drop because the President who is appointed upon, that calls upon the House to make sure it prioritizes the process of completing, approving the audit reports. Otherwise, then the exercise we are undertaking now will be another exercise in futility. With those few remarks, Honorable Speaker, I support and I hope we'll be given adequate time to review so that we can present amendments in the committee of the whole House. Thank you, Honorable Speaker.
To reply? Move to reply.
Thank you, Honorable Speaker. Honorable Speaker, let me thank the members who have contributed on this bill. And as they've all said, this is a very critical bill at this time, especially in relation to not just aligning the provisions of the Public Audit Act to what the court said and to the court, but also in ensuring that we have that public resources are utilized, as many of the speakers have said, in an effective and efficient manner, and in a way that we ensure that there is economic value to the people of Kenya. Honorable Speaker, let me thank them all and say we will be lining up this bill for a committee of the whole, and some of the few issues that, reservations that I've had from the speakers, we will ensure and encourage even those who are not here to look at the bill and see what else that we can do to enrich it further, to ensure that the amendments that we bring in the committee of the whole only further enrich this public audit bill and the Public Audit Act. Honorable Speaker, with those few remarks, I beg to reply.
Honorable members, I now put the question that the Public Audit Amendment Bill, National Assembly Bill number 4 of 2024 be read a second time. Will as many as of that opinion say aye? Aye. Will as many as of the contrary opinion say nay? The ayes have it. Your point of order, Honorable Majority Leader.
A bill for an act of parliament to amend the Public Audit Act 2015 and for connected purposes.
Thank you, Honorable Speaker. I beg your indulgence to move a short procedural motion. Looking at the time, it's 5 o'clock, Honorable Speaker, and the next order of business in the Committee of the Whole, the Cooperative Bill, Bill number 7 of 2024.
Bill, National Assembly Bill number 7, 2024, proceeds until completion. Will as many as of that opinion say aye? Aye. Will as many as that of the contrary opinion say nay? The ayes have it.
Very well, order members, and we are in the committee. Stage on the Cooperative Bill, National Assembly Bill number 7 of 2024.
Clauses 3.
I propose the question that clauses 3 and 4 be part of the bill. There are no amendments on this one. I now put the question that clauses 3 and 4 be part of the bill. Will as many as of that opinion say aye? Will as many of contrary opinion say nay? Of contrary opinion say nay. The ayes have it.
Clause 5.
I propose the question that clause 5 be part of the bill. Yes, there's an amendment, Chair.
Thank you. I propose that the amendment be as it appears in the order paper, and the justification is that the committee resolved to introduce a subclause to provide that all SACCO societies shall be registered, and resolved to introduce a subclause to provide that all SACCO societies shall be registered and regulated under the Cooperatives Act, and where there is a conflict in the laws, the Cooperatives Act shall apply.
I propose the question that clause 5 be amended as proposed by the chair.
Put the question.
I now put the question that clause 5 be amended as proposed by the chair. Will as many as without opinion say aye? Will as many as contrary opinion say nay? The ayes have it. I now put the question that clause 5 as amended be part of the bill. Will as many as without opinion say aye? Will as many as contrary opinion say nay? The ayes have it.
Clauses 6 and 7.
I propose the question that clauses 6 and 7 be part of the bill. No amendments. I now put the question that clauses 6 and 7 be part of the bill. Will as many as without opinion say aye? Will as many as contrary opinion say nay? The ayes have it.
Clause 8.
I propose the question that clause 8 be part of the bill. Chair, is there an amendment?
Yes, clause 8. I propose that the clause 8 be as it appears in the order paper, and the justification is that the proposal resolves to delete the clauses 8.2 and 13.2b on the grounds that the professional bodies that exist are not registered with the Registrar of Societies, and therefore should not be used to discriminate persons who may qualify for appointment as the commissioner or county director for cooperatives. Thank you.
I propose the question that clause 8 be amended as proposed by the chair. I now put the question that clause 8 be amended as proposed by the chair. Will as many of that opinion say aye? Will as many of contrary opinion say nay? The ayes have it. I now put the question that clause 8 as amended be part of the bill. Will as many of that opinion say aye? Will as many of contrary opinion say nay? The ayes have it.
Clause 9.
I propose the question that clause 9 be part of the bill.
I beg to move that clause 9 be amended as it appears in the order paper, and the justification is that the committee considered submissions from the public and resolved to sponsor this amendment to clarify the commissioner that the commissioner shall register cooperatives and the county directors for cooperatives shall regulate the operations of cooperatives in the various counties respectively. Thank you.
Honorable members, I propose the question that clause 9 be amended as proposed by the chair. I now put the question that clause 9 be amended as proposed by the chair. Will as many as of that opinion say aye? Aye. Will as many of contrary opinion say nay? The ayes have it. I now put the question that clause 9 as amended be part of the bill. Will as many of that opinion say aye? Aye. Will as many of contrary opinion say nay? The ayes have it.
Clauses 10 and 11.
I propose the question that clauses 10 and 11 be part of the bill. There are no amendments, honorable members, and now put the question that clauses 10 and 11 be part of the bill. Will as many of that opinion say aye? Aye. Will as many of contrary opinion say nay? The ayes have it.
Clause 12.
I propose the question that clause 12 be part of the bill.
Thank you. I propose that the minimum qualifications for appointment.
Chair, please always capture the word amended.
As yes, amended. And the proposal is that the minimum qualifications for appointment as technical staff in the office of the County Director of Cooperatives. I submit.
Honorable members, I propose the question that clause 12 be amended as proposed by the chair. Yes, leader.
Honorable Speaker, I wanted to support. Honorable Speaker, if you look at clause 12, it is giving the responsibility to the County Public Service Board to appoint such number of technical officers to the office of the County Director for Cooperatives. Honorable Speaker, the fallacy you find with many of our county governments and these county public service boards is that people resort to appointing people on the basis of whether they support the governors in the county. And you find so many people being appointed to very important offices who do not qualify. And I think I want to support the committee's position that all these technical officers being appointed by the County Public Service Board must, and the word is shall, have relevant academic qualifications, competencies, and experience in cooperative management practice, because you cannot supervise the running of cooperatives if you do not know how they should be managed. And to improve on the governance of our cooperatives across the board, whether it's in the dairy sector, coffee, or tea, is important that those who are supervising them or superintending over the management and governance of these cooperatives are people who have relevant skills and qualifications, to avoid the position where county service boards go to the villages because Mr. Kimani Ichung'wah is a very good supporter of the governor or the local MCA. Is a class 8 dropout or a class 7 dropout with no relevant skills and experience in that area. They are appointed to those boards, Honorable Speaker. And you find many county public service boards appointing the hecklers in their towns and villages to very important positions. Therefore, it's important what the committee is doing to ensure that they appoint people who have relevant skills and training in the particular sector. And I support, Honorable Speaker.
Very well. And now put the question that clause 12 be amended as proposed by the members of contrary opinion say nay. The ayes have it. I now put the question that clause 12 as amended be part of the bill. Will ask many of that opinion say aye. Aye. Will ask many of the contrary opinion say nay. The ayes have it.
Clause 13.
I propose the question that clause 13 be part of the bill.
I beg to move that clause 13 be amended as it appears in the order paper, and the justification is that the bodies that are being referred to do not exist, and therefore that would discriminate qualifications. Thank you.
I now propose the question that clause 13 be amended as proposed by the chair. Honorable members, I now put the question that clause 13 be amended as proposed by the chair. Will as many of that opinion say aye? Will as many of contrary opinion say nay? The ayes have it. I now put the question that clause 13 as amended be part of the bill. Will as many of that opinion say aye? Will as many of the contrary opinion say nay? The ayes have it.
Clause 14.
I propose the question that clause 14 be part of the bill.
I propose that the clause 14 be amended as it appears in the order paper, and the justification for that is that the submissions from the public resolved that the sponsor of this amendment to clarify the commissioner shall register cooperatives, and the county should operate, should only or regulate the cooperatives. Thank you.
I propose the question that clause 14 be amended as proposed by the chair. I now put the question that clause 14 be amended as proposed by the chair. Will as many of that opinion say aye? Will as many of the contrary opinion say nay? The ayes have it. I now put the question that clause 14 as amended be part of the bill. Will as many of that opinion say aye? Will as many of the contrary opinion say nay? The ayes have it.
Clause 15.
I propose the question that clause 15 be part of the bill.
Chair, we propose that clause 15 be amended as it appears in the order paper, and the justification is to provide or to allow counties to submit audited reports every 5 months after the financial year ends. Thank you.
I propose the question that clause 15 be amended as proposed by the chair. I now put the question that clause 15 be amended as proposed by the chair. Will as many of that opinion say aye? Will as many of the contrary opinion say nay? The clause 15 as amended be part of the bill. Will as many of that opinion say aye? Will as many as our contrary opinion say nay? The ayes have it.
Clause 16.
I propose the question that clause 6. No, take that again.
Clause 16.
I propose the question that clause 16 be part of the bill. There's no amendment. I now put the question that clause 16 be part of the bill. Will as many as that opinion say aye? Will as many as the contrary opinion say nay? The ayes have it.
17.
I propose the question that clause 17 be part of the bill. Chair.
Chair, I propose that clause 17 be amended to as it appears in the order paper, and the justification is that this amendment will provide the forum that shall act as a mechanism for alternative dispute resolution
I propose the question that 18 and 19 be part of the bill. There are no amendments to these, honorable members. I now put the question that clauses 18 and 19 be part of the bill. Will as many as of that opinion say aye? Will as many as of contrary opinion say nay? The ayes have it.
Clause 20.
I propose the question that clause 20 be part of the bill. Move on.
Thank you, Chair. I propose that we amend clause 20 as it appears in the order paper, and this is to help provide or ensure that persons who apply for membership to more than one primary cooperative disclose their membership and financial liability to the Commissioner and to the prospective cooperatives.
Honorable members, I propose the question that clause 20 be amended as proposed by the chair. Honorable members, I now put the question that clause 20 be amended as proposed by the chair. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it. I now put the question that clause 20 as amended be part of the bill. Will as many as of that opinion say aye? Will as many as of contrary opinion say nay? The ayes have it.
Clause 21.
I propose the question that clause 21 be part of the bill. Is there an amendment on this one? Chair.
Chair, I propose that clause 21 be amended as it appears in the order paper, and the justification is that the cooperatives may not be registered under one for the purposes of without any approval by the Commissioner. Thank you.
I propose the question that clause 21 be amended as proposed by the chair. I now put the question that clause 21 be amended as proposed by the chair. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it. I now put the question that clause 21 as amended be part of the bill. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it.
Clause 22.
I propose the question that clause 22 be part of the bill.
Chair, I propose that clause 22 be amended as it appears on the order paper, and the justify compliance with clause 29 of the same copy of this act, and also to make it easier for a group of persons to form a cooperative, reducing the threshold that currently exists from 25 to 20 persons. For a group of persons to form a cooperative, reducing the threshold that currently exists from 25 to 20 persons. Thank you.
Very well, I propose the question that clause 23 be amended as proposed by the chair.
Put the question.
I now put the question that clause 23 be amended as proposed by the chair. Will as many as of that opinion say aye? Aye. Will as many as of the contrary opinion say nay? Aye. Aye. Will as many as of the contrary opinion say nay? The ayes have it. I now put the question that clause 23 as amended be part of the bill. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it.
Clauses 24, 25, and 26.
I propose the question that clauses 24, 25, and 26 be part of the bill. Members, there are no amendments on this one, and therefore I now put the question that clauses 24, 25, and 26 be part of the bill. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it.
Clause 27.
I propose the question that clause 27 be part of the bill.
Clause 27.
I propose the question that clause 27 be part of the bill. Move on. Move on.
Thank you. I propose that clause 27 be amended as it appears. Indication for it is that this is to make it to make it clear and comply with drafting style as per the National Assembly. Thank you.
I propose the question that
primary cooperative to be 20 members, and for the secondary cooperative, 5 primary cooperatives. Thank you.
Honourable members, I propose the question that clause 29 be amended as proposed by the mover. Please, you are in order now that I've proposed. You may proceed and speak on this.
Chair, I just wanted the chair to clarify, just for clarity, when she says that 5 cooperatives, do those 5 cooperatives have a minimum threshold in terms of how many members in each of the cooperatives should comprise the 5?
Thank you, Chair. The primary cooperative shall have 20 members. And we are saying 5 primary cooperatives can form a secondary cooperative, meaning that if every primary cooperative will be 20 times 5, which is 100 members, that is the minimum a secondary cooperative should have. Cooperative, housing cooperative, transport cooperative, worker cooperative, and those kind of cooperatives. So under this particular clause, We are saying that a member or a cooperative cannot be a member. We are saying that a member or a cooperative cannot be in more than one cooperative unless the commissioner approves which type of cooperative, because that clarification or justification in terms of cooperatives has already been taken care of under clause 20.
Yes, Honorable Undo.
I just want to educate our members that yes, there ought to be a criteria, but that will fall within regulations. You can't regulate even the minor details. Give the discretion or some powers to the commissioner that whenever there is a conflict, they can administratively solve it without going into rigorous processes, but they'll be in the regulations. Thank you, Honorable Chair.
Chair. You know, I need to be on record.
Order, Honorable Choma, please. You may proceed, but Chair, please approach the table as you proceed.
Chair, I want to be on record that the reason why we were so earnestly looking for this cooperative bill is because of the mess that the cooperative commissioners have caused in our primary cooperatives. We have had a lot of issues, a lot of irregularities, lack of standards under the sanction of the same cooperative commissioners. So how do you then make a new law and still accommodate them and give them the same power they had? And that was the spirit of the to authorize. To what extent? And that is what Honorable Udo is saying. Otherwise, we are going to get ourselves back to where we were. The reason why most of the farmers have lost their assets and properties is because somebody sanctioned in the name of commissioners. How do we tame them so that they do not overuse the power we give them through this bill? Otherwise, it will be retrogressive for us to have a new cooperative bill and still give the same offenders an opportunity to repeat the offense.
Honorable Mchomba, we hear you very well and you are very clear. Honorable Undo, yes.
That's why this is where laws are made, this particular time. But let me just try to let the because then I'll be talking.
Honorable Mchomba,
they're on a banter.
You are arguing very well, and Oundo would want you to hear him on this.
It's a banter of people from Kiambu, members from Kiambu.
Proceed, Oundo.
You know that in a banter, members of Kiambu. Honorable Mchomba, when you look at the national cooperative policy that we passed in the last parliament, was actually to address the fears you are raising. And the fears you are raising is that there used to be briefcase promoters of cooperative societies who would go for gullible members, register here, register here, register here, and hoping and understanding that the principle of cooperative is people of common bond, with a common bond, and democratic rights to vote. Whichever they want. So essentially, what we are saying, that the commissioner has got somebody can apply for exemption, but that exemption is going to be guided based on the regulations. Therefore, Honorable Speaker, if the Honorable Member can look at that amendment and at clause 30, subsection 3, it will clearly explain The regulations will set out procedures where the exemption can be granted and where the exemption can be denied. It's unfortunate that she's busy.
The same objects, then we do not need to register another cooperative to do the same kind of business. I'll give you an example. In my constituency, we grow tea. So if there is a cooperative that is already a tea growing cooperative, then we don't need to register another cooperative of a tea growing with the same membership, because that would mean that this other cooperative would be for the purposes of going to corn members.
So that we try to make cooperatives physically viable. So this is one of the reasons why, after extensive public participation, these powers was given to the commissioner, so that we try to delimit boundaries and say, if commission or other cooperative X already exists, let everybody, say T, belong to that one cooperative, instead of having fragmented cooperatives which may eventually lead to small cooperatives which are not sustainable. So I think for that reason we should support these amendments.
Very well. Honorable members, you still have 1 minute, because we heard you extensively.
Chair, I ask to be forgiven for bringing this issue so heavily, because
there's no forgiveness here. Just state your point.
Pardon me for reprojecting the issue. You know, the issue. That has been there, the issue that we wanted to sort once and for all through making this law, is the issue of somebody coming up with a cooperative society, fleece Kenyans' money, then after 2 years, deregisters the cooperative and registers the same cooperative. So this is what I want an assurance from, that for me to support this, that problem is going to be sorted.
Honorable Mchomba, I was a keen follower of this debate, and I'm a very interested person. And they have explained very keenly and very.
Clauses 31, 32, 33, 32, 33, 34, and 35.
I propose the question that clauses 31, 32, 33, 34, and 35 be part of the bill. Honorable members, there are no amendments on these ones, and therefore proceed to put the question that clauses 31, 32, 33, 34, and 35 be part of the bill. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it.
Clause 36.
I propose the question that clause 36 be part of the bill. Mover.
Thank you. I propose that clause 36 be amended as it appears in the order paper, and this is basically for redrafting to make it clear, especially on the word corporate body, to bring consistency and clarity in the bill.
I propose the question that clause 36 be amended as proposed by the mover. I now put the question that clause 36 be amended as proposed by the mover. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it. I now put the question that clause 36 as amended be part of the bill. Will as many as of that opinion say aye? Will as many as the contrary opinion say nay? The ayes have it.
Clauses 37, 38, 39, 40, 41, 42, and 43.
Honorable members, I propose the question that clauses 37, 38, 39, 40, 41, 42, and 43 be part of the bill. Honorable members, there are no amendments on this one, and therefore proceed to put the question that clauses 37, 38, 39, 40, 41, 42, and 43 be part of the bill. Will as many as of that opinion say aye? Will as many as of a contrary opinion say nay? The ayes have it.
Clause 44.
I propose the question that clause 44 be part of the bill. Mover.
Thank you. I propose that clause 44 be amended as it appears in the order paper. And basically this amendment is to delete the words or the board of directors, subject to ratification by members at a general meeting. And this amendment is therefore to prevent misuse of power to ratify at the AGM. Thank you.
I propose the question that clause 44 be amended as proposed by the mover. I now put the question that clause 44 be amended as proposed by the mover. Will as many as without opinion say aye? Aye. Will as many as with contrary opinion say nay? I now put the question that clause 44 as amended be part of the bill. Will as many as without opinion say aye? Aye. Will as many as with contrary opinion say nay? The ayes have it.
Clauses 45 and 46.
I propose the question that clauses 45 and 46 be part of the bill. I now put the question that clauses 45 and 46 be part of the bill. Will as many as without opinion say aye? Aye. Will as many as of contrary opinion say nay? The ayes have it. Honorable members, there were no amendments on clauses 45 and 46.
Clause 47.
I propose the question that clause 47 be part of the bill. Mover.
Thank you, Chair. I propose clause 47 be amended as it appears in the order paper, and this is basically to provide, we remove the limitation of membership to producer cooperatives as it is just discriminatory. It's only mentioning one type of cooperative.
I propose the question that clause 47 be amended as proposed by the mover. I now put the question that clause 47 be amended as proposed by the mover. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it. I proceed to put the question that clause 47 as amended be part of the bill. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it.
Clauses 48 and 49.
I propose the question that clauses 48 and 49 be part of the bill. Honorable members, there are no amendments. I therefore put the question that clauses 48 and 49 be part of the bill. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it.
Clause 50.
I propose the question that clause 50 be part of the bill. Mover.
Thank you, Chair. I propose that clause 50 be amended as it appears on the order paper and basically, this amendment is to provide for compliance with the Data Protection Act.
Proposed by the mover. Proceed, Honorable Wamichomba.
Chair, allow me to thank the chairperson of this committee and the committee that found it worth to bring this kind of amendment. I fully support. In the past, producers, cooperatives have had their information leaked to circles, lenders, commercial ventures, suppliers, to fleece producers, societies, and cooperatives their money. Very, very good. I am one of those that made the Data Protection Parliament, and I'm happy that we are aligning to the Act. Thank you.
Honorable Anthony Lodge.
Thank you, Honorable Chair. And then once again, thank you, Honorable Chair. And then once again, this was one of the concerns during the public participation on how data can be misused, and therefore we considered it necessary that we insert a provision that data be protected. I also want to join Honorable Wamichomba, with whom I served in the ICT committee last parliament, where the Data Protection Act was put in place. This is a progressive move, and it is in line with our current laws. I support.
Honorable members, I now put the question that clause 50 be amended as proposed by the mover. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it. I now put the question that clause 50 as amended be part of the bill. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it.
Clauses 51, 52, 53, and 54.
I propose the question that clauses 51, 52, 53, and 54 be part of the bill. Honorable members, there are no amendments on these ones, and I therefore proceed to put the question that clauses 51, 52, 53, and 54 be part of the bill. Will as aye? Will as many as the contrary opinion say nay? The ayes have it.
Clause 55.
I propose the question that clause 55 be part of the bill. Mover.
Thank you, Chair. I propose that clause 55 be amended as it appears on the order paper, and the justification is this is to resolve the proposed amendments to provide for electronic filing of any records. Thank you.
I propose the question that clause 55 be amended as proposed by the mover. I now proceed to put the, yes. Let's hear Honorable Mayaka.
Thank you, Chair. Chair, I want to support this particular amendment, the addition of hard copy or electronic copy, because this then goes in line and complies with the current is also allowed. So this, for that particular fact, I do support this amendment. Thank you.
Yes, Honorable Anthony Lodge.
To support this and again progressive move, the government is currently undertaking digitization of all its records, and in terms of good governance and Mongozo practice, I think it would be in order that the cooperatives not only files good records in terms of physical copies, but also has digital copies which can be accessed virtually. I support.
Honorable members, I now put the question that clause 55 be amended as proposed by the mover. Will as many as without opinion say aye? Will as many as with contrary opinion say nay? The ayes have it. I now put the question that clause 55 as amended be part of the bill. Will as many as without opinion say aye? Will as many as with contrary opinion say nay? The ayes have it.
Clause 56.
I propose the question that clause 56 be part of the bill. I now put the question that clause 56 be part of the bill. Will as many as without opinion say aye? Will as many as with contrary opinion say nay? The ayes have it.
Clause 50.
Chair, I propose that clause 57 be amended as it appears on the order paper, and the justification for this is to enable a person who is a member of the cooperatives to write to the commissioner or the county director of cooperatives to convene a meeting where the directors of a cooperative have failed to call for a meeting.
I propose the question that clause 57 be amended as proposed by the chair. Yes, yes, Muchomba first. Take the first bite.
Chair, I rise to fully support this amendment, and the justification given therein by the chair is applicable, noting that this is going to sort a lot of governance issues that have been experienced in the past, where the directors of cooperatives could collude with the commissioner of cooperatives to do things that are against the members of the society. Therefore, I support.
Honorable Anthony Lodge.
Chair, I think one of the big problems that befell the cooperatives that we are trying to sort right now was a question of directors, not only the collapse of cooperatives, but the loss of millions of shillings of hard-earned money by farmers and people who deposit their money with cooperatives. This now therefore gives members the opportunity to call these directors to order by writing to the commissioners and thereby be able to force a meeting to be called. I support.
Honorable members, I now put the question that clause be amended as proposed by the chair. Will as many as without opinion say aye? Will as many as with contrary opinion say nay? The ayes have it. I now put the question that clause 57 as amended be part of the bill. Will as many as without opinion say aye? Will as many as with contrary opinion say nay? The ayes have it.
Clauses 58, 59, 60, and 61.
I propose the question that clauses 58, 59, 60, and 61 be part of the bill. No amendments. I proceed to put the question that clauses 58, 59, 60, and 61 be part of the bill. Will as many as without opinion say aye? Will as many as with contrary opinion say nay? The ayes have it.
Clause 62.
I propose the question that clause 62 be part of the bill. Mover.
Thank you, Chair. I propose that clause 62 be amended as it appears in the order paper, and the justification is to provide for staggered appointment of directors. This is to ensure that there is institutional memory and to provide for a limit, a term limit that a person may serve as a director. Thank you.
I propose the question that clause 62 be amended as proposed by the chair. Oh, yes. Let me hear from Honorable Dorothy. Mwalimu.
Thank you, Chair. I support this particular amendment. This will go a long way in improving governance because when people, there will be transparency and accountability, Chair, and I strongly support this amendment.
Honorable Undo.
Chair, if there was any clause that elicited emotions and strong and passionate discussions and debate in public participation and even the public participation in the villages and in the various county headquarters, was the issue of the term for directors. Very emotive issue. And probably to help merge the different views, the committee felt that, first of all, it must be staggered. So there's institutional memory. Secondly, we said you cannot serve for more certain number of terms. You can serve, take a break, then come back. It's also neat, Honorable Chair, so that this cry of embezzlement, misuse of resources, and all those things, there is a break in between when we can look at it. Chair, let me give you an example. One said, there was a mzee somewhere in Mount Kenya region who joined the COP as a director when he was in the early 20s. I did not even have a bicycle. By now, he has got a fleet of transport vehicles and is the richest person, and he can have his way in all elections. You cannot beat him in an election.
Very well, your point is made. Honorable Dagala Beatrice. And that's the last one we are taking, and then I get the chair. Will as many as of that opinion say aye? Aye. Will as many as of the opinion say nay? The ayes have it. I proceed to put the question that clause 62 as amended be part of the bill. Will as many as of that opinion say aye? Will as many as of the opinion say nay? The ayes have it.
Clauses 63, 64, 65, 66, 67, 68, 69, 70, 71, and 72.
I propose the question that clauses 63, 64, 65, 66, 67, 68, 69, 70, 71, and 72 be part of the bill. Honorable members, all these clauses don't have amendments, and I therefore proceed to put the question that clauses 63, 64, 65, 66, 67, 68, 69, 70, 71, and 72 be part of the bill. Will as many as of that opinion say aye? Will as many as the contrary opinion say nay? The ayes have it. Very well. What's the point of order, Honorable Anthony Lodge?
Chair, I don't know whether I missed something. Was clause 62A moved, or was it moved as part of 62, the one that deals with payment of expenses?
Well, we are
or
very
was
much.
It dropped? If it was dropped, then I stand corrected.
We are very much aware of that clause 62, but it will come in as a new clause. Chair, do you have a comment on that? Later.
I just wanted to clarify to the member that it is a new clause, so it will be moved later.
Very well.
Yeah.
Honorable Anthony Luoch, are we together? We may proceed.
Clause 73.
I propose the question that clause 73 be part of the bill. Mover.
Chair, I propose that clause 73 be amended as it appears in the order paper. This particular clause, Chair, elicited a lot of response and comments from both the county governments and the ministry. And this particular amendment will enable the county governments to issue demand notices as proposed by the submissions of the Joint Technical Committee from the State Department and from the Ministry of Small and Medium Enterprises and the County Council of Governors.
Very well. I propose the question that clause 73 be amended as proposed by the chair. Yes, Honorable Anthony Loach.
Chair, one of the things that we grappled with during public participation was to set out boundaries and limits of a county director to the extent that we do not allow arbitrariness. Where notices are issued without reference to the provisions of Article 47. So this new amendment enables notice to be issued, but to the extent that these notices must be reasonable and that these notices must take into account the right for fair administrative action to the members affected. Thank you.
Chair, I rise to note
Thank you, Chair. Yes, he will have done so in consultation. And remember, by the time these notices are being written, it is because the cooperative has not complied. And because of lack of such compliance, the members who are within the cooperative will have also suffered. And therefore, this notice is very important to ensure that these cooperatives at all times comply, and where they fail to comply, the notices will compel the cooperatives to comply and provide information that is required. So yes, by the time the notices are being given, they will have already been notified. Thank you.
I now put the question that clause 73 be amended as proposed by the chair. Will as many as without opinion say aye? Will as many as with contrary opinion say nay? The ayes have it. And now put the question that clause 73 as amended be part of the bill. Will as many as without opinion say aye? Will as many as with contrary opinion say nay? The ayes have it.
Clauses 74, 75, and 76.
I propose the question that clauses 74, 75, and 76 be part of the bill. I proceed to put the question that clauses 74, 75, and 76 be part of the bill. Will as many as with contrary opinion say nay?
Clause 77.
I propose the question that clause 77 be part of the bill. Mover.
Thank you, Chair. We propose that clause 77 be deleted as it appears in the order paper. And the reason for this is this amendment is to ensure that cooperatives exercise due diligence in mitigating risks and ensure insurers loans in case of death of a member. Thank you.
Well, let me first propose the question that clause 77 be deleted as proposed by the chair. Honorable Anthony Loach.
Chair, this amendment, the deletion would save a situation in which the estate of a deceased person who had no idea about debts or liabilities that they had and have no means by which to be able to meet these are saved from being auctioned and being run down. And I think this has happened in very, very many instances. I think this would be a good provision, and therefore I support it.
Honorable members, I now put the question that clause 77 be deleted as proposed by the chair. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it.
Clause 78.
I propose the question that clause 78 be part of the bill. Chair.
Thank you, Chair. I propose that clause 78 be amended as it appears on the order paper, and the justification is to enable payment of any demand to a cooperative within 60 days of the death of any member.
I propose the question that clause 78 be amended as proposed by the chair. Yes, let's see, Economist Makali Mulu, Honorable.
Yeah, thank you very much, Honorable Chair. I think that amendment is very important, and more so when you fix the time in which money must be paid, because there has been a necessary delay in these payments, so I support.
Wamuchomba, Honorable.
Chair, if there is anything that has made our members of producer cooperatives go bankrupt and dissolve cooperatives and fight and kill each other, like the famous Boy Committee Cooperative Society in Kiambu County, where members have killed each other over allegations of working behind the scenes to be the debt collector on behalf of the cooperative. For this, I support.
Very well, honorable members. I now propose the question. I now put the question that clause 78 be amended as proposed by the chair. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it. I now put the question that clause 78 as amended be part of the bill. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it.
Clauses 79, 80, 81, 82, 83, and 84.
Honorable members, I propose the question that clauses 79 bill. Honorable members, there are no amendments on this one, and I therefore proceed to put the question that clauses 79, 80, 81, 82, 83, and 84 be part of the bill. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it.
Clause 85.
I propose the question that clause 85 be part of the bill. Mover.
Thank you, Chair. I propose that clause 85 be amended as it appears in the order paper, and the justification is to provide clarity on that particular clause.
I propose the question that clause 85 amended as proposed by the mover. Is it a point of order or you want to contribute? Yes, Honorable Mayaka.
Thank you, Chair. Chair, and maybe the Chair could clarify on this, because I see her amendment is talking about prescribe, but on the bill it is prescribed. Semantically speaking, those are have two very different meanings. So maybe the Chair would want to clarify.
Could you bring out the meanings now that you seem to be English?
Chair, when you prescribe, you're talking about the continuous tense. Prescribed, you're talking about the past continuous tense.
Thank you for your magnanimity. Yes, Chair.
Thank you. I think I will go with the amendment of the member to prescribe, not prescribed. Prescribe, the word prescribe.
Okay, Honorable Anthony Oluoch.
Chair, we are dealing with different issues here. First, the proposed amendment, what it seeks to do is to say that, inserting the words in regulations under by the Cabinet Secretary appearing after the word prescribe. This word, as put in the order paper, Chair, is the word as it should have been in the text of the bill. And I think that the text of the bill is correct. If you read the text of the bill, it says a cooperative shall not invest its funds or money, members' deposit, in non-core activities beyond any limits as may be prescribed. Now, if you use Honorable Mayaka's context, you would be saying, as really anchored on that word prescribed. It is merely to add certain words, and those words are in regulations under by the cabinet, so that even the words in the order paper should still have been prescribed as they appear on the bill. Thank you.
Very well, we together. Chair, you still want to make a comment on that?
I want to agree with Honorable Anthony Olwoch that it should be as it is in the bill that is prescribed.
Very well, honorable members, I now put the question that clause 85 be amended as proposed by the chair. Will as many as without opinion say aye? Will as many as with contrary opinion say nay? The ayes have it. I now put the question that clause 85 as amended be part of the bill. Will as many as without opinion say aye? Will as many as with contrary opinion say nay? The ayes have it.
Clause 86.
I propose the question that clause 86 be part of the bill. Mover.
Thank you, Chair. I propose that clause 86 be amended to empower the Cabinet Secretary to enact regulations or investment in companies, including operations of holding cooperatives.
I propose the question that clause 86 be amended as proposed by the chair. Honorable members, I proceed to put the question that clause 86 be amended as proposed by the chair. Will as many as without opinion say aye? Will as many as with contrary opinion say nay? The ayes have it. I now put the question that clause 86 as amended be part of the bill. Will as many as without opinion say aye? Will as many as with contrary opinion say nay? The ayes have it.
Clauses 87, 88, 89, 90, 91, and 92.
Honorable members, I propose the question that clauses 87, 88, 89, 90, 91, and 92 be part of the bill, and there are no amendments on these ones, and therefore proceed to put the question that clauses 87, 88, 89, 90, 91, and as many as of that opinion say aye. Will as many as of contrary opinion say nay? The ayes have it.
Clauses 93, 94, 95, 96, 97, 98, and 99.
Honorable members, I propose the question that clauses 93, 94, 95, 96, 97. And 99 be part of the bill. Again, there are no amendments. I proceed to put the question that clauses 93, 94, 95, 96, 97, 98, and 99 be part of the bill. Will as many as without opinion say aye? Will as many as with contrary opinion say nay? The ayes have it.
Clauses 100, 101, 102,
of recommending to the Commissioner the registration of dormant cooperatives to the county directors of cooperatives, because
limiting any other activity that may come from a perceived competition. What do I say, Mr. Speaker? I want to give an example of the current situation right now, where women reps, like the ones in the house, can confirm with me they have a fund called GAF, where they put money in small fund called GAF, where they put money in small self-help groups and welfare associations, which may grow to become cooperatives. Sometimes you find county governors having issues with those growth because they are being backed by a politician who may be a competition. How do you sort out this issue? So for me, I have a reservation for this amendment.
Honorable Mchomba, then tell us what to do. But meanwhile, let me give it to Honorable Anthony Olwoch. Remember, this is the third reading, so you just go for specifics on the law. We shall come back to you later. Honorable Anthony Oluoch, proceed.
Chair, a clear reading of these and I hope Honorable Wamuchomba is listening. Honorable Wamuchomba, I wanted
Your
you to hear
attention
this
again, Honorable Wamuchomba.
because, first of all, the powers of cancellation belong to the commissioner and not to the county director. And if you look at clause B on the order paper, it says that a county director may recommend so that for your comfort and for purposes of any potential interference by
adequately on this matter. I, having been in this committee since last time, cooperative will have to undertake due diligence, do investigation, and satisfy himself or herself. The reason given for cancellation or dissolution, the reason given for cancellation or dissolution are valid and not politically motivated. There's layered them. There is layered them. Yeah. Then in a case, Honorable Wamuchomba, if you look at Wamuchomba, if you look at the act, the bill, it says a person aggrieved by an order of the commission under section 1, subsection 1, may appeal against.
Aye. Will as many as the counter opinion say nay. The ayes have it. Opinion say nay. The ayes have it.
Clauses 108, 109, 110, and 111.
I propose the question that clauses 108, 109, 110, and 111 be part of the bill. I proceed to put the question that clauses 108, 109, 110, and 111 be part of the bill. Will as many as without opinion say aye? Will as many as the counter opinion say nay? The ayes have it.
Clauses 100.
Opinion say nay. The ayes have it.
Clauses 112, 113, 114, 115, 116, 117, clauses 118, clauses 119, clauses 120, clause 121, clause 122, and clause 123.
I propose the question that clauses 112, 113, 114, 115, 116, 117, 118, 119, 120, 121, 122, and 123 be part of the bill. Honorable members, there are no amendments on all those clauses, and therefore proceed to put the question that clauses 112, 113, 114, 115, 116, 117, 118, 119, 120, 121, 122, and 123 be part of the bill. Will as many as other opinions say aye? Will as many as the counter opinions say nay? The ayes have it.
Clause 124.
I propose the question that clause 124 be part of the bill. Mover.
Thank you, Chair. I propose that clause 124 be amended as it appears in the order paper And the justification for this amendment Chair is that it will provide for 2 deputy chairpersons in the tribunal, and this is an expansion of membership of the tribunal to 9 members to allow the tribunal to have at least 3 sittings or 3 panels that can move across the country, because we realize that we have so many cases with the tribunal, and therefore expanding the tribunal will help sort out the country on cooperatives.
I propose the question that close. Yes, Honorable Dorothy.
Thank you, Chair. I support this amendment that we have 2 deputies. The tribunal is the one that takes care of all the issues in the cooperatives movement. Thank you, Chair.
Honorable Mayaka.
Thank you, Honorable Chair. Chair, I do support the first part of the amendment, but on the second one, I have a concern. And my concern is if we are increasing the number of the tribunal members to 6, and I foresee a situation where you are having a vote, and this is an even number. I wouldn't advise for us to have an even number there. We ideally should have an odd number so that in case of a vote, then we do have a clear direction.
Anton Oluoch. Anton Oluoch. I think this committee is well guarded with its members. Honorable Anton Oluoch, let's hear you.
Guarded by none other than yours truly. Honorable Mayaka is my very good friend. Honorable Mayaka, the clause there expanded to 6 other members. Remember, there is a chairperson. So the tie is broken by 1 so that it becomes 7. But also now, just to make one more contribution on this, I think one of the reasons I support this amendment is also for gender reasons, so that when you have 2 deputies, it is then possible to have 1 being of the other gender. So it's also a very progressive provision. I thank you.
Honorable members, I now put the question that clause 124 be amended as proposed by the chair. Will ask many as of that opinion say aye. Will ask many as of the opinion say nay. The ayes have it. And now put the question that clause 124 as amended be part of the bill. Will ask many as of that opinion say aye. Will ask many as of the opinion say nay. The ayes have it.
Clauses 125, 126, 127, 128, 129, and 130.
I propose the question that clauses 125, 126, 127, 128, 129, and 130 be part of the bill. There being no amendments on these ones, I proceed to put the question that clauses 125, 126, 127, 128, 129, and 130 be part of the bill. Will as many as of that opinion say aye. Will as many as of the opinion say nay. The ayes have it.
Clauses 131, 132, 133, 134, 135, 136, 137, 138, 139, and 140.
Honorable members, I propose the question. The clauses 131, 132, 133, 134, 135, 136, 137, 138, 139, and 140 be part of the bill. No amendments. I proceed to put the question that clauses 131, 132, 133, 134, 135, 136, 137, 138, 139, and 140 be part of the bill. Will as many as without opinion say aye. Will
50, 151, 152, and clause 153. 2 and clause 153.
I propose the question that clauses 150, 151, 152, and 153 be part of the bill. I put the question that clauses 150, 151, 152, and 153 be part of the bill. Will as many of those opinions say aye? Will as many of the contrary opinions say nay? The ayes have it.
Clause 154.
I propose the question that clause 154 be part of the bill. Mover.
Thank you, Chair. I propose that clause 154 be amended as it appears in the order paper, and the justification is to provide that the Cooperative Development Fund be shared between the two counties, that is the national government and the county governments, at the ratio of 60-40.
I propose the question that clause 154 be amended as proposed by the mover. Anthony Lodge, Honorable.
Chair, I support these amendments, but I want to persuade my chair and vice that a similar provision as has been put under 154.2, that the Cabinet Secretary shall give the rates, or rather the source of the funds shall consist of contributions made by the cooperatives in the sums and rate as the Cabinet Secretary shall prescribe. But when you go to subclause 3 of the bill on how this fund shall be applied in terms of what it shall do, I don't know. I want to persuade my chair that we consider putting a provisions that the Cabinet Secretary shall provide regulations on how we can apply and use these funds. But otherwise, I support. So if that is possible, then we need to move this. Provisions later in an amended form. Thank you. But I support.
Chair, any comment?
Chair, I think it is a proposal that can be looked at, but maybe when this fund is in place, we can bring that amendment much later.
You have been. I now put the question that clause 154 as amended be part of the bill. Will as many as without upon the
Clause 155.
I propose the question that clause 155 be part of the bill. Chair.
Thank you, Chair. I propose that clause 155 be amended as it appears in the order paper. And the justification for this is to empower the Cabinet Secretary to prescribe affirmative action guidelines for the benefit of special interest groups of women, youth, persons with disability, and the minority and marginalized communities in cooperatives and in compliance with this constitution.
Honourable members, I now propose the question that clause 155 be amended as proposed by the chair. Honourable Mchomba.
Chair, for a long time, Honourable Chair, when it comes to the primary producers cooperatives, women have been the laborers. They work to produce milk, but when it comes to the milk card, and the accounting behind the milk card is for the men. And so the women end up becoming laborers, but they are not the earners. Mr. Speaker, I'm very, very, very excited, Chair. I'm so excited to see this kind of an amendment because it's...
I honestly feel it is time that all the interest groups are on the table, on the decision-making table. Honorable Chair, I want to say it has been long overdue that you go to cooperative societies, like in the teaching fraternity, Chair, where the women are the majority, almost 50-50, and they are never included when it comes to election, because elections are skewed towards a certain group. Chair, I am very excited too, and I'm happy that time has come for all the interest groups, the disability, the women to be on the decision-making table.
Honorable Anthony Oluoch, let the excitement and the continue. Adagala. Honorable Adagala.
Thank you, Chair. Actually, I support
There's
this.
a win here for the women.
I support this.
Of directors, this has been a thorn in the flesh of all cooperatives.
Very well.
And so we support this, and we now know that women will also be part and parcel of cooperatives, especially at the board of directors, where there's always a challenge. Thank you, Chair.
Chair, I am excited about the excitement. Let me say, like Honorable Luchungwa always says, I am a father of girls. And so when the girls are excited about gender on the table, I am also very excited. But let me speak for the boys. This provision is progressive, not only to the excited about gender on the table, I am also very excited. But let me speak for the boys. This provision is progressive, not only to the extent that we have gender inclusion in it, we also have youth, we have persons with disabilities, we have special interest groups in line with Article 100 of the Constitution, in line with Article 27, and in line with the foundational principles under Article 10. But now that I am on this provision, allow me to go back to the proposal I made to my chairs, and I can now see that the Cabinet Secretary will be able to make regulations, Chair, for, among other issues, 154(2)JJ, provide for the operationalization and management of the Cooperative Development Fund. So I think I'm satisfied that the regulations will cover.
That clause 55 be amended as proposed by the chair. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it. And now put the question that clause 155 as amended be part of the. Will as many as of the contrary opinion say nay? The ayes have it.
Clauses 156, 157, 158, 9, 160, 161, 162, 163, 164, 165, 166, 167, and clause 168.
I propose the question that clauses 156, 157, 158, 159, 160, 161, 162, 163, 164, 165, 166, 167, and 168 be part of the bill. Honorable members, there are no amendments on these ones. I proceed to put the question that clauses 156, 157, 158, 159, 160, 161, 162, 163, 164, 165, 166, 167, and 168 be part of the bill. Will as many as of that opinion say aye? Will as many as of the opinion say nay? The ayes have it.
New clause 62A.
I propose the most
during the general meeting. And 3, this section shall apply to a member of the supervisory board. The justification for this, Chair, is to enable for regulations of allowances and other payments of directors to avoid situations where there is conflict of interest.
I propose the question that clause 62A be now read a second time. No, we can allow debate. Yes, Honorable Anthony Oluoch.
Chair, I support this amendment. We must encourage a situation in which board of directors do not become permanent. We encourage commissioners to find other things to do, commissioners in different things, so that they do not interfere with the day-to-day running of the specific institutions. And where there are legitimate claims that they have for things that they have expended, they can be paid a recompense for that particular one without necessarily being paid a salary, and also to guard against any possible conflict of interest. I support.
Chair, it's good tenets of corporate governance dictates there must be a clear separation between directors and management. Directors should be allowed to issue policy, and the superintend or supervise. They're not supposed to undertake day-to-day activities. That you find a director, when he's going to buy a cup of tea, going to any errand, has to pass through the offices to take a cup of tea, has to pass through the offices to read the newspapers. We need to make it as unattractive as possible. Let them come for the board meetings. They're remunerated by way of sitting allowances. If there are transport allowances to be paid, a rate, and that's how things should do, so that we allow the cooperative to move on. Thank you very much.
In 1 minute, Honorable Mchomba.
Chair, the reason why we really wanted a new bill, a cooperative bill, is so that we can eliminate people we call career board members. Career board members are members who are always wanting to be elected as board members or assert themselves for long and earn salaries like any other person employed. So this amendment comes in hand to make sure that we break the cycle of thefts and domination of career board members in cooperative. I support.
That's enough, honorable members. I put the question that the new clause 62A be now read a second time. Will as many as that opinion say aye? Will as many of the counter opinion say nay? The ayes have it. I now propose the question that new clause 62A be part of the bill. I proceed to put the question that the new clause 62A be part of the bill. Will as many of that opinion say aye? Will as many of the counter opinion say nay? The ayes have it.
First schedule, second schedule, and third schedule.
Honorable members, I propose the question that schedule, second schedule, and third schedule be the schedule of the bill. I now put the question that the first schedule, the second schedule, and the third schedule be the schedules of the bill. Will as many as without opinion say aye? Will as many as with contrary opinion say nay? The ayes have it. Clause 2 be part of the bill. I now put the question that clause 2 be part of the bill. Will as many as without opinion say aye? Will as many as with contrary opinion say nay? The ayes have it.
Title.
I propose the question that the title be the title of the bill. I now put the question that the title be the title of the bill. Will as many as without opinion say aye? Will as many as with contrary opinion say nay? The ayes have it.
Clause 1.
I propose the question that clause 1 be part of the bill. I now put the question that clause 1 be part of the bill. Will as many as without opinion say aye? Will as many as with contrary opinion say nay? The ayes have it. Mover.
Honorable Chairperson, I beg to move that the committee do report to the House its consideration of the Cooperative Bill, National Assembly Bill number 7 of 2024, and its approval thereof with amendments.
Very well, honorable members. I put the question that the committee do adopt to the House its consideration of the Cooperative Bill, National Assembly Bill number 7 of 2024, and its approval thereof with amendments. Will as many as without opinion say aye? Aye. Will as many as with contrary opinion say nay? The ayes have it. Honorable Speaker, I beg to report that the Committee of the Whole House has considered the Cooperative Bill, National Assembly Bill number 7 of 2024 and approved the same with amendments.
Mover of the bill. ML.
Honorable Speaker, I beg to move that this House do agree with the report of the Committee of the Whole House on its consideration of the Cooperatives Bill, National Assembly Bill number 7 of 2024, and also request the Honorable Beatrice Adagala to second the motion.
Thank you. I second.